Good afternoon, everyone. Thanks for joining us today. My name is Matthew Copel. I'm the Open Access and Intellectual Property Librarian at Princeton University. We're excited to talk to you folks a little bit about metadata, copyright, and contracts today. Just a quick shout out to one of our panelists who was not able to make it, Kathleen De Laurenti at Johns Hopkins University, was also a partner in this whole process. With us, of course, as well is Katie Zimmerman from MIT and Kyle Courtney from Harvard University. We're going to be covering a good bit of ground, including some foundational stuff, and then more of the meat and potatoes that you folks have come to hear about. But we're gonna move fast and hopefully leave enough time for some conversation at the end. What we're talking about today is represented in a paper that is now available for your downloading and reading pleasure by that QR code and link. That'll be up on the last slide as well. In case I'll give it a second for those. Yeah, go ahead, make those snaps. All right, and a reminder of the conference code of conduct. Everybody, be cool. So yeah, there we go. Real quick origin story of this. We wanted to address a gap that we noticed in the literature and analyze the copyright law surrounding the status of bibliographic metadata. There's not been a lot written about this, actually not really much at all. And using that analysis, we wanted to make a recommendation, really a call for participation in the community to recommend open sharing under a CC0 public domain dedication of the metadata that is created by all of us in the community. Very quickly, this is very basic, so please forgive me. A lot of you know a lot more about this part of it than any of us do. But there are several different types of metadata that we're talking about in the library context. With thanks to NISO and all of you fine cataloging and metadata folks out there, we know that we share a very basic understanding that metadata is information we create, share to describe things. It's designed to help us discover and understand and relay information. These are facts. These are facts about the materials and world that we live in, and facts are what they are. And the nature of these facts about this material is not really dissimilar to what you might find in, for example, a phone book, which we'll come back to in a moment. So real quick overview of the fundamentals of copyright. Authors and creators of original works automatically hold copyrights to those works. Within the bundle of rights that are granted to them are to reproduce, distribute, make derivatives, publicly perform, and publicly display those works. Each creator is given a limited monopoly over a period of time so that they may profit from their work. However, none of the things that I just said apply to facts. So, copyright only protects original works in a fixed tangible medium of expression that contain sufficient creativity. That spark of creativity is what drives something over the threshold into copyrightability. Data is fact. Data can be arranged creatively and in some cases expressed uniquely. In our context, we are a standards-driven profession, and we are reliant on interoperability to share, grow, and evolve. So, remember I was talking about phone books? Remember this one? Feist Publications. So Feist offered to pay 11 telephone companies for the right to use their white pages listings. Only one company refused. Feist then verified some of the names on its own, but lifted others from Rural's white pages without compensation or consent. They were sued for copyright infringement, but the Supreme Court said that alphabetical listing of neighborhood residents is not an original compilation of facts. It does not matter when assessing copyrightability how much work went into assembling those facts. No, that's sweat of the brow stuff. That work, whatever form it takes, needs some modicum of creativity, that spark, to be copyrightable. And let me just say, this is not to devalue the work that does go into these important records in this process. It is valuable, but we are talking about what it means once it's created, once it's out in the world, once it's assembled, once those facts are observed. So, a couple other key legal cases. In Meshworks versus Toyota, 3D models of existing cars created with hyper accuracy were recognized as unoriginal because it just is what it is. It doesn't take on new copyright. Let's see here. And also in Bender versus West, unique identifiers were not enough to grant copyright to something that was already outside the scope of protection. So this is, again, looking back at the idea that facts, metadata, is not copyrightable. This is as close as the case law comes to it. Real quick, these two are attorneys. I'm not. I'm just a librarian who fell into this area. So what it's worth. With that, I will pass it on to Katie, who has more to share.
Thanks. All right. Okay, so facts are not copyrightable. The other thing that's legally in play here is contracts. So even non-copyrightable metadata can be restricted via contracts and frequently is. And restrictive contracting can limit libraries' abilities to share their data and use data from others. So the elephantine example in the room. So this is an example of an OCLC agreement. This is a redacted copy of an invoice. It's got the customer information, and then you might be a little bit small to read, but at the bottom there's a block of text inserted into the invoice that says that this transaction is subject to the OCLC framework agreement, their standard license contract, and it's subject to the default one that's available online if you don't have negotiated terms otherwise. So even if you haven't engaged with that contract, you haven't seen it directly, by paying this invoice, you're agreeing to those terms. So what do those terms say? They say a lot of things. This is a short excerpt of them. This is from one of the schedules that covers when you receive metadata specifically. So you're agreeing to a bunch of things as an institution entering into this agreement. You're providing data as well as receiving data. And then there are also all of these other documents that are incorporated into here. So you're agreeing to abide by the principles and the guidelines and the policy, which are all defined terms that are defined as these other policies that live outside of the contract. You're not directly negotiating them. They're external documents. And the policy in particular refers to the WorldCat Rights and Responsibilities Statement, which includes these provisions. You have to make reasonable efforts to attribute the OCLC for the data. You have to make reasonable efforts to ensure that subsequent reuse is consistent with this policy and that it supports the long-term viability and utility of WorldCat. You can't engage in mass distribution without OCLC's prior consent, and you're not engaging in other activities that diminish the value of WorldCat and the OCLC cooperative. So this is, there's a lot of reasonable efforts in here. There's a lot of kind of hedges in here, but this is attempting to restrict the ability of member libraries to share their metadata under their own terms. So how can you share your metadata according to this policy? In 2012, OCLC recommended the ODCBY license, which is an open database commons license that requires attribution. So you can share your metadata with attribution back to OCLC or to the data source. There are some issues with attribution-based distribution of metadata, though. It's never really recommended that you use attribution-based an attribution license for data sharing, because it just gets very, very messy very quickly. You're combining data from multiple sources. Now you're providing attribution for this particular field over here and that field over there. It results in a chilling effect on your ability to actually use the data. And also the ODC-BY license applies only to the database structure itself, not to the contents of the database. So it's not purporting to apply to the metadata either. And the whole thing just kind of creates a gray area where it doesn't need to be. And I believe this is where I hand it off to you.
Oh, we're going to go fast. So what we've heard is a question that I think has not been discussed before, just maybe never written down. And so OCLC's role in this obviously is important and critical as libraries function as a result of their existence with regards to interlibrary loan and data and all this other stuff. But in 1983, there was a relatively contentious moment when OCLC registered the copyright on the entire OCLC database. And we went back and found some literature on this. I would call them blog posts, but they weren't blog posts, right? People actually wrote this down and shared it. It was called a Xerox machine. And they shared it amongst each other. And it was some folks thought this as an attempt to register all the copyright and all the records created and shared by OCU members. And a lot of member libraries at that time objected to that because they were saying, well, we're making the catalog records and we think they might be devoid of copyright. President of OCLC at the time in 1983 claimed that the purpose of registering the copyright in the database was to protect it from misappropriation by non-members and other database producers. Now, not much has changed since that attitude in 1983. As Katie lined out here, there are implications for libraries in multiple layers of contract terms that exist across the board here. The framework agreement, the WorldCat rights and responsibilities, the guidelines for contributions, and the WorldCat principles of cooperation. Some of these are represented online, as Katie showed out, some are represented in the actual contract itself. When we're trying to line up all of these things based on the copyright law and the case law that says facts aren't copyrightable, and combined with the licensing, which is a business ethic that OCLC employs, we see some conflict, right? So open metadata policies already exist. What we're talking about isn't like new necessarily. In 2011, for example, when the University of Florida was cataloging its records before it sent it off, it attached a CC0 statement because they felt that it should be open and available, and they thought that the membership in the university would agree with that. In 2022, University of Florida got a surprise letter in the mail saying that the inclusion of CC0 is an unrestricted use of the record which is not aligned with the WorldCat rights and responsibilities, and said, we're going to delete that from the records here in OCLC and don't do it again. Now, I know the University of Florida was proud of the fact that they took this position the earliest I can imagine. So this represents a shift in policy over the decade. So we're kind of exploring the whys of that. Now, previously in 2012, OCLC recognized that the WCRR statement is not a legally binding document, and that interpretations of community norms within this cooperative may differ, but releasing the data is ultimately the choice of the OCLC member institution. And so those are important words, but of course, that was on their blog. It's still there, hanging together. It's still a blog that is active by OCLC. I read it. So that was kind of the first salvo that we saw. There's a determinative policy shift here. I would call it circling the wagons on the ability to prevent competition in this space. But let me tell you another tale. OCLC and Clarivate got into a scrap. Is everyone here aware of that? It's a settled case. Good. Okay. You came to the right place. So there was legal action against Clarivate in its development of Metadata. And library partners were using catalog records and data. So OCLC issued under 2 business tort laws and 2 conspiracy claims. And I say the word tort here, I want to be clear, it's not a delicious treat I had downstairs. A tort is an infringement of a right leading to monetary or liability or injunctions. So tortious interference with business is a very old law. In fact, it goes back to ancient Rome. The idea that interfering with a competitor's business was some of the first cases in the history, right? What you're doing is interfering with our business. And so this has been used in the past, and some scholars have said that some are anti-competitive in nature, these tortious interference with business. The outcome of this case was settled, so we never saw it go to trial, so to speak. There was a couple of motion documents. But I think it's important that we understand what this means, because this happened, just 2 years ago. So tortious interference with contract implies something, right? It implies there has been a breach of a contract, right? So a party, Clarivate, induced another party under a contract, the libraries that were doing that, to breach that contract. And they did this by saying, hey, can we have your metadata, right, in order to build this particular product. Now, they weren't building a bibliographic database. They were doing something different. I don't know what it was going to be because it never got off the ground. But the question here is certainly, well, if there was an inducement of somebody to breach a contract, that means that the libraries that were in question breached that contract. There's an inference there. Now, OCLC did not sue any libraries for breach of contract. But the implication of this tort is that there was a breach. So the settled case could reveal a couple things. The court in one of the motions said, well, it's okay to permit subscribers to extract WorldCat data to enrich their own catalogs, right? And that makes sense. And again, I repeat it here. Subscribers are permitted to transfer and make available such to individual scholars for library consortia or other libraries, museums, education, scholarly institutions, whether they're members or non-members. Now that's good for collaborative use. You would think that that's an important aspect because libraries are talking to each other, libraries are doing the work, our catalogers are there making these records. However, according to the court, this authorization is limited. So what is that limitation that the court looked at? Well, the limitation is that the WCRR states that subscribers should not engage in other activities that diminish the value of WorldCat to the OCLC collaborative. And that was one of those terms that Katie brought up. And the court's interpretation of this was interesting. So, what is a diminishing value of open metadata? Well, if you give it to a competitor, that might diminish the value. That's what I think the court looked at, right? The transfer of records from the libraries to a competitor diminishes the value and transcends the permission that exists in all our agreement. And I think that's interesting. I don't necessarily find myself defending two large library vendors in this space, but I understand why the conflict occurred. But I think the lesson for libraries is kind of interesting. So if we are thinking about linked data and the future of data and what we're doing with our metadata that we created at all our libraries, can we transfer those records to competitors? It doesn't seem like we can. Am I clear on that? I don't know. It's a draft paper, so we're not clear on everything. I turned to them first. That sounds right? But amongst libraries, I give that a sort of. Because providing WorldCat records and metadata, things that make WorldCat valuable, through a competitor's program that ultimately makes records and metadata freely available to the general public, that diminishes the value. But what if providing WorldCat records and metadata through a peer library program that ultimately makes the records and metadata freely available to the general public, as long as libraries don't become competitors? Now, this is an interesting moment, right? Because certainly we don't consider ourselves competitors, but as we've seen in the open access movement and public domain rights and things being locked up behind paywalls, sometimes we do the work, we share the work, and then the work gets sold back to us, right? This exists. This exists in cataloging, this exists in open access, this exists in public domain, this exists in a lot of places. And the intellectual labor that's going on, even though the reward is not copyright, there's still a reward there of sorts, right? And the reward shouldn't libraries be able to use this and share this with the public at large? And note, the settled case does mention two library systems, right? OCLC learned that the defendants had contacted the executive director of Boston Library Consortium, and they also highlighted Brandeis University, who was also an OCLC subscriber that had an early adopter. And these were folks that were working with Metadata at the time. But just to be clear, they were not sued. I want to be clear on that, just in case there's folks in the audience here. But nevertheless, there's a mystery underlying this. So despite the fact that metadata is generally considered uncopyrightable, it can be locked up via license. But it could be unlocked for library partners as long as they don't overstep their bounds, of which we're still trying to define those bounds in the paper. And I, of course, encourage you to read the paper because this is only a 28-minute summary of everything we've gone over. So we've learned a lot from that particular case. We've learned a lot from prior actions. We've learned a lot from reading the license. Now Matthew's going to close it out and ask what we do with all this.
Thank you. So again, what do we do with all this? Please do read the paper, talk about it, but talk about it here and now as well. We want you to engage on this. We want you to take it back with you. We want you to talk to your administration locally. We want to talk to your catalog and metadata teams because ultimately there are some opportunities to issue local policies. For those of you who are in consortia, to consider issuing consortial policies. For those of you who are vendors, who are creating records and distributing them, or otherwise facilitating the sharing of records, take a stand, make a policy that explicitly makes these open. There is the way to do that is to apply a CC0 public domain dedication to these records. We have some model policies. They are in the paper. That's a lot of text on the screen. That's one of the policies. There's also a draft community open data policy. And finally, there is some model contract language that you can use, whether it's with a vendor who you're working with or with a contractor who is creating metadata records for you. Inserting this language into those agreements makes clear where the control sits and how it is becoming open. And that's really the point, so that we have the ability to continue to cultivate a community project of our metadata records. And it is up to all of us. And when I say that, it is not just us as libraries, because this is an ecosystem where we are all working together. We can do that without that friction, without that kind of, the shadow adversarial stance that seems to pop up here and there across our different relationships. If we do that, we will advance knowledge further. We will be able to make strides and find creative solutions to the problems that we see now and tomorrow. So with that, we covered a lot of, as mentioned, we covered a lot of ground. Again, take a look at the preprint. It'll probably go through some changes. And hopefully those are going to be based in part on some of the discussion we have here today. We welcome your questions. Oh, here. And I think we have a runner with a mic. All right. Anybody? Oh, right over there.
Thank you. Hello. I'm Sophia Mosby from Texas State University. This was a really great presentation. Desperately trying to download it on my poor phone. But will these slides be available? Because there was just so much great information. I know we'll be able to reference the article, but as just like a great way to take back to our university.
That's always the number one question. Yes, slides will be available. Of course. Because otherwise you just have to take pictures over and over of the slides, and I see everyone do that. We'll make them available.
And this will be repeated in the virtual sessions as well. So if there are colleagues at your home institutions who you'd like to have them hear this conversation and take part in it virtually, I guess we've got a month till then. And hopefully the sky doesn't fall between now and then.
Hi, and thank y'all so much for this great presentation. I was wondering, with the open policies about the open metadata examples that y'all showed, are those like things that you're working on implementing at your own institutions, or do you have like on the ground kind of examples of people who are doing that and how you got that buy-in, if so?
Sure. So the paper has a chart. It's a chart, right? A chart of everyone that currently has policies, but I can speak to Harvard Library's policy in 2012, we released 24 million records under a CC0 license, and made that available in one of our databases that we could spit out there. At the time, that's why the blog post was written by OCLC. We negotiated with them. That's their language, which says, yep, it's ultimately up to the members. Maybe we disagree, but it didn't come to letters or lawsuits. And we did that specifically because we thought there's great value in metadata being shared amongst the community at large. And I just liked, I mean, we can't not say AI, right? The value of this in a space that's very interesting now that we're all discussing to a certain extent, I think is tenfold. Again, Matthew said something very important that I want to highlight. This is not devaluing the catalog records themselves. They are highly valuable. They are accurate. They are important to finding stuff. But copyright isn't necessarily the reward, right? I think the interoperability and the factual data is the reward. So yes, so we've had that release at least, 12 years, something like that. So.
I'll add that you'll notice in the paper of the institutions, both in the academic field and beyond, there are some public and non-US institutions that have those licenses as well. But you'll see lots of different flavors and approaches. Some of them are consistent. Some of them do things that it's like, oh, okay, that's great, and don't necessarily conform with this model. But I don't think that matters. It's that people are thinking about it critically, locally, for their contexts, and trying to move in the direction of making these records more flexible, more available, and it's important. One thing and I don't know if we touched on this in the policy itself, or in the model policy, we talk about insofar as there is anything copyrightable in this record. We're not saying this is copyrighted and we're publicly, or dedicating it to the public domain. We're saying in the case that there is some thin copyright, and it happens, especially with content like abstracts, there might be some copyrightable material there. Increasingly, those abstracts we're seeing written by AI, and we see those asterisks in the catalog records as well. And as we know, that AI content is not copyrightable if it's solely composed by the machine. But again, it's pushing back and saying, if there is any layer of copyright here, it's gone. So that type of commitment is important, but you'll see a bunch of different flavors in the report. Question up here.
Longest distance.
It's been a really great talk, and I just wondered if you could build a little bit on that abstract point, because I think on the other pieces of metadata, I completely follow the logic and the argument, but I think abstracts have complexity around them, and I just wondered if you could build on that a little bit. But thank you for a great presentation so far.
So I agree. I think an abstract that's written by a human is almost certainly copyrightable. So we're largely just kind of excluding that from the analysis in a lot of this. In a lot of cases, though, the abstract is going to be copyrightable to, like, the abstract is going to be copyrightable to the author or the publisher, whoever wrote it, not to whoever is compiling the metadata. So it's kind of it has its own set of like gray areas and weirdnesses to it, but it's a different set than from the rest of the metadata.
And I'll add that there certainly is the opportunity from those publishers to say, these 3 lines, the value is where they live in the record, not in how they sit in our catalog copy. I think that and speaking back to what Katie talked about with the layers of licenses and how complicated that gets when it's a Russian doll of, well, this part is and this part isn't, and that's where again the idea of a common effort by the community to say, no, there might be pieces, but we're going to try to move the conversation forward. So it has to be a conscious choice with that kind of material. Yeah.
Michael Kane, Columbia University. this is perhaps an aside to this conversation, but I just want to point out that OCLC is a membership-owned cooperative, and we as members vote for the leadership of OCLC. Therefore, if you are concerned about the actions that OCLC has taken, I would recommend that you lobby your voting representative at your institution to perhaps change the direction that OCLC is going.
You got something?
I believe in democracy too, sometimes. But I think that the value in that is important, right? OCLC is built of us, for us, by us, sort of. And certainly, I think that value of when it was formed up, when it was in Ohio, can still be reflected today. So just here, thumbs up, sir. Win.
Thanks again. This is Beth Danker. I'm with the Colorado Alliance of Research Libraries. And we have a product called Gold Rush. This is not an advertisement for that product, but we use bibliographic metadata in that product. And when that lawsuit happened with Clarivate, I think we were a little bit worried that we would not be able to use that metadata anymore at some point if they chose that we were the next step for that. Because they also have a competing product with us now. Not that the two are apples to apples by far, but we're also not using like the OCLC number as part of the match key when we're matching in the analytics tool. So technically, we're not using their portion of the, I don't know. And technically, it's very complicated, but I think there are many other reasons that maybe we haven't even thought of the reasons that the bibliographic metadata might want to be used at this point, that down the road we might want to use at some point for libraries uses or for researcher uses or whatever. And so I think there's lots of reasons to, I mean, I definitely support what you're talking about with the CC0 license. I think there's lots of uses that we might want to use our own data for eventually. Yeah.
So I wrote this part of the paper, which we didn't address in the thing. So you give me a nice opportunity. The OCN number, I believe we have multiple posts from OCLC that says, oh, that should be like, that's like a public domain thing. Like they've said that. Now, whether or not they still support that, I don't know. There's been policy shifts, as we know. But there is a case on point about this against West Publishing that tried to copyright the pagination. So, you know, West takes law, republishes it and sells it back to us. Familiar. And that idea that they have their distinct pagination. And so when somebody tried to copy that, they sued. And generally, pages aren't held to pagination. So identifying numbers to a certain extent. But nevertheless, I think it was interesting that you were like, you know what, we'll just leave that out. And nevertheless, run it. By the way, Gold Rush is an incredible name for a Colorado resource. Well done there. Yeah, that was really super cool.
Now's your chance. Oh, there we go. Yeah.
What about Sky River?
What about Sky River? All right. So Sky River was also in a scrap in the 2010s or 12s. That is also represented in the paper. We talk about that lawsuit. Obviously, there's some similarity between what Sky River was doing and what Clarivate was trying to accomplish with use of those records. I know that Sky River was looking to be as broad and as big as impactful, and I think was representing the true spirit of library to library collaboration on that data set. And I think that is, unfortunate that there was a legal scrap there as well. But again, it's part of the pattern of what I referred to as circling the wagons. So we need to figure out instead of having circling the wagons and Sky River and Clarivator example and plus the letters, there's got to be a way that we can all win in this particular space. And for those that stop me in the hall before and say, am I advocating that we leave OCLC forever behind? No. To be clear, maybe there's people from OCLC here. I understand how that works. I understand the benefit to the library community, but I think the labor that our catalogers and metadata experts are doing has value to the community outside of that space as well. And again, I think what the Gold Rush lady, I'm sorry, I'm calling you Gold Rush lady, said, is important, that we are capable of seeing also in the same way how the usefulness may be run, but there's things we haven't thought of yet. Open metadata, let's just drop the meta. Open data drives a lot of stuff in this space. Scholarly publishing, access to information, new modes of scholarship that we have not seen before. So I think that's an important part of it. So I'm hoping that we can put those kind of previous fights aside for the purposes of making more informed decisions about the tools and the products and the things that we have. So thank you. All right. As I see, there's a reluctance to raise questions here. And as I see, the QR code's been up for a while now. I think we're going to call it. Just one thing. Policy does not exist in a vacuum, right? The model policies we were outlining here today are an attempt to say, okay, have a conversation in-house about this. Talk to your cataloging librarians. Talk to your metadata experts. They'll know this. Then talk to your licensing friends and consider the fact that the policy doesn't upend anything, but it does what libraries always have done, which is increase access to information. And in this case, the information we think is completely open by all the case law and statutory law and copyright law that we can see. So openness is something that should be cherished in this environment where we're hitting more paywalls than we ever have before. So we see this as just the next evolution of metadata into linked data into things that we can't see before. So thank you for your time. Please read the paper, and we welcome comments. Have a good afternoon and the rest of your presence.